Good morning, everybody. Today is the 13th of January 2025. We're going to deal with the matter of Mengo versus Mbenenge. We're sitting as a judicial tribunal. We are hereby formally constituted. I'm chairing the proceedings. My name is Bernard M. Mwepe, and to my right is retired Judge C. Pretorius, and to my left is Advocate G. Mashava SC. As I say, we are duly constituted as the judicial panel. Yes. And the leader of evidence in this matter will be Advocate S. Skippers. And may I then ask the parties to place themselves on record, starting with the complainant.
Chairperson, can I just check, would you like the complainant herself to place herself on record or her representatives?
No.
Just the representatives, yes. Chairperson, I am Nasreen Raja Badanda. I appear instructed by the Women's Legal Centre. I'm here to advise the complainant in this matter.
Yes, for the respondent, please.
Thank you, Chairperson. My name is Muzi Skakane SC. I'm the lead counsel together with Matansala SC and Ms. Da Silva SC. We here for the respondent, briefed by the attorneys KMNS Attorney Incorporated. Thank you.
Yes, thank you. Excuse me. For the benefit of everybody, including the media especially, who have been allowed to be in here in terms of the ruling that I handed down a few weeks ago, let me clarify the procedure to the extent that it is necessary to do so. Firstly, in line with the ruling, we are going to have some parts of the proceedings open to the public, like now, and at some point we will return to the default position, meaning that the hearings will be in camera. The tribunal will try to assist as far as possible, to assist legal representative and also the media for their benefit, to try and indicate at which point the public hearing would cease, and at what point the in-camera hearing will commence. For the benefit of the parties, generally speaking, and I'm saying generally speaking because I assume that you have duly acquainted yourselves with the ruling, and of course the papers, and the media, of course, I assume that they've acquainted themselves with the ruling. Generally speaking, therefore, we are going to conduct proceedings to a point where we will stop. Once we reach a point where the public will have to be excused. In broad terms, looking at the papers, it would appear as though we would deal with the interaction or exchange of WhatsApp messages from about maybe June 2021 to about maybe February or May 2022. We know that particularly after June 2022, there was a long pause with regard to the interaction between the parties until November. So, as I said, generally speaking, we will deal with WhatsApp messages and interactions that started from the beginning until about February or May. I don't want to be precise about that. Subject to this, that those WhatsApp messages in that period, which the respondents denies came from him, or denies that they came from his cell phone, those ones we will not be dealt with in public, but in camera. As I said, We expect as the panel that the parties would have acquainted themselves with the ruling and the papers especially. But that is a broad indication. This is, in other words, this is a hybrid situation, and the matter must therefore have to be conducted accordingly. This would mean, and I want to state this in advance so that the parties can prepare their notes and themselves accordingly for purposes of cross-examination. Excuse me. This would mean that the witness will testify, the complainant will testify in public in respect of these areas that I've outlined, finish her evidence in chief or her complaint in chief, after which she would then be cross-examined in respect of that area that falls within a public hearing. After some time, we may move into the next phase, that is in camera. She may be recalled, and possibly so to the complainant. I don't know who is going to actually testify or not. I don't know. We will see how proceedings unfold. Just suffice it to state this, that after she has finished her evidence in chief on the complaint with regard to matters falling under a public hearing, she'll be open to cross-examination, again in public, in respect of that area. Thereafter, the tribunal will give directive regarding the further conduct of proceedings. If there is anyone who doesn't understand, please say so. And if there are members of the media who don't understand and they don't want to find themselves on the wrong side of the ruling and therefore the law, please approach Mbali for clarification. If she is not clear, she will come to us. We'll clarify whatever you want to be clarified. Thank you. Advocate Skippers, you, or should I wait until somebody asks a question for clarification?
Yes. Thank you, Chair. It's not a clarification. It's an issue that relates to whether or not the ruling. But I do think, I'm new in the matter, but I've read. But I do think it's a matter I would like to raise in chambers first with the panel. I think we should have. It's something I can raise here, but I think the decent thing to do is to. I've told my learned friend, Ms. Raja Butlander, but it relates to the impracticality of the ruling for the proceedings, and I would like to tell the panel what our stance is, but I would like to do that in chambers. I'm so sorry not to have raised it there when we were introducing each other.
Okay, all right. Let's shelve that for a while and proceed to hear whether there are other questions or queries that need to be clarified now before we adjourn into chambers to prosecute the issue that you're raising. I don't see any hand, and therefore we are going to adjourn. How many days do you are going to take in seeing us in chambers?
How many days? I hope it will be less than a day.
Okay, just for the public, I'm sure in 10 minutes' time we should be back.
Yes.
Yes, yeah, in 10 minutes' time we'll be back. Thank you. We are adjourned. Thank you. Thank you, Mr. Sikakane. I think what you should do about the issues you saw us in chambers on, I think you should make formal submissions in that regard, just for the purpose of record.
Thank you, Chair. Let me just start by saying there is a ruling, and this ruling stands, and it's a ruling that was sought and opposed, and I think the submissions I'm going to make are no attack on the ruling in any way. But as the chairperson and the panel will know, I'm new in the matter, but clients keep looking at what is actually in the public interest to do and what is practicable. And one of the issues when we must determine to the panel as to which issue must be done public and which one must be done in camera, it becomes difficult, not just for counsel, it can become burdensome even for the witnesses who may have to be cross-examined, re-examined twice because the issues are intertwined. And so when looking at those practicalities and knowing that without any attack on the ruling, it's as good as it was sought, this panel is permitted to determine its procedures. And our view, having looked at the practicalities, is that, well, and what exactly is in the interest of the public and the judiciary, our submission is that the matter be ventilated publicly if the panel is so inclined. Of course, this was an issue I had with other 6 preliminary issues that I was to raise in stating that we are ready to proceed, but I thought maybe let me end with that one. But as I said, I don't want anyone to misconstrue our submissions as some kind of undermining of the ruling. No, we just think practically we are in your hands, but we would prefer that every issue be ventilated here publicly. Thank you, Chair. I may leave this issue first before I proceed to the other ones that we were going to do when each one of us starts. Thank you, Chair.
Are those other issues related to the issue of whether or not some parts of the hearing being public or in hearing, or is something
Not at all, not at all.
We need to dispose of this one
This,
first.
we can dispose of this issue
All right.
independently.
Okay, right. Advocate Bartlett.
Thank you, Chairperson. Chairperson, you will recall that the complainant wished for these proceedings to be publicly held. She has indicated that she recognizes how difficult that will be for her, but that already her matter has been ventilated in public, and so she wishes the opportunity to clear her name and to place her version on record. So we certainly would welcome a ruling that this matter be heard openly and that the media be entitled to report fully on the evidence. In addition, we do believe that transparency in a process such as this, which is important, it's sensitive, and it is the first of its kind, is particularly important. So we would support such a ruling.
I think those aspects you submitted
Yes.
before the ruling, and the ruling has dealt with them.
Yes,
So
and
don't re-argue them because they didn't convince the ruling, the consultation to say otherwise.
We
So
accept
don't
fully.
re-argue the merits of your argument. I just wanted to hear your response to that proposition.
Yes. No, we agree with the proposition by Advocate Sikakane.
Yes,
We think that it
thank
should
you.
be public. We respect that the ruling has been made, and we respect the ruling. But we would agree that it should be
Thank you.
held from a
Yes.
practical perspective.
All
Thank
right.
you.
Mr. Sikakane, let us be clear as to what the procedure here is and what the issue is. The fact of the matter is that there's a ruling which stands. So in effect, what you're doing, and this is how I see your proposition, you are bringing in new facts which were not there at the time when the ruling was made. And that new fact is relevant, and that new fact is this. The respondent no longer objects against the matter being heard publicly. That is a new development that's coming, which was not there when the ruling was made. It was the opposite. Now, the question is, in light of this new development, is the tribunal inclined to persist with the ruling, or is the tribunal inclined not only to listen to this new development, but also to consider it, and having considered it, feels persuaded to move from the default position to a public hearing? I make this point because let us be very clear about this. The ruling was not necessarily meant to protect a particular individual, but the image of the judiciary, which was why the law says, as the president of the tribunal, I must consult with the Chief Justice on this issue, because the Chief Justice is the ultimate protector of the image of the judiciary. Now, we have noted your point. I think this is the same point that you made when we were in chambers. Essentially, namely that your client no longer, for whatever reasons, no longer objects against the matter being heard publicly. And I must put a rider there that we note and respect your client's position. We don't want to go into the reasons why, because we may find that some of the reasons, including what I would describe as imagined problems as a result of a hybrid situation, may actually not arise. But that is besides the point. The important thing is you are saying to us, for whatever reasons, your client has no objection against the matter being heard in public. And that's the point on which you came to see us. You haven't added anything to it. You have succinctly summarized what you have told us in chambers. It is important for me to emphasize that what you've just said is exactly what told us in chambers. Because after you told us what you said in chambers, in accordance with the Act, I reconsulted with the Chief Justice telephonically because I'm required as the President of the Tribunal to determine the procedure as to whether in camera or public. I must do that in consultation with the Chief Justice. If you are to address to me now and I suddenly decide otherwise, it will be irregular. So on the basis of what you told me, I reconsulted with the Chief Justice telephonically and presented the facts to her. And after that consultation is going to be born, possibly, an amended ruling. But that's the procedure where it is now. But I think some members may want to ask questions to you about this.
I just want to know, why did you wait until such a late stage? Because this has been ongoing for quite some time, and now right at the beginning of the hearing, you come and you request that it be, I think on the 9th of January, whilst the ruling was given and nobody said anything about it. And the ruling was given to protect the judiciary more than it was to protect your client, I think. But your client was protected because the ruling was in favour of your client as well. But I just wanted to know, why did you take so long to come to this decision? I mean, your client has been represented by senior counsel throughout.
Thank you, Judge Torres. I appreciate that. I appreciate it. I don't even want to use the excuse that I was briefed a day before Christmas. I'm new in the matter. It's no sufficient reason. But preparation for a hearing sometimes is the one that reveals certain things that may not assist in determining a matter. And I think this was birthed by that kind of preparation, apart from the fact that I was new and have a different perspective about how practical this would be. So while I apologize for my client that it was raised late and my attorneys, but it was not because of any shouldiveness. It was because in preparation in getting to deal with this use, you certainly have to take into account the prejudices, the impracticalities of doing things. And lastly, I'm not the determinant of this, and you also have to consider what exactly is in the interest of the judiciary. Is it when something is hidden and therefore there is speculation out there about it, or is to open it up for people to see what it is that is being dealt with so that they can trust the process? So it was a combination of all of those, but really about why it was late, I think it's partly because of the intricacies of preparing for something that is like this, that's emotional, that's detailed, that no one knows which the right way to do them. And my late involvement, which came with another perspective that, well, I don't think I can cross-examine to and fro, in and out, public and not public. Those are my submissions.
Thank you, Mr. Sikakane.
Thank you.
Well, we understand you came late in the matter, Mr. Sikakane, and this is a complex matter with many ramifications. Now, here comes the ruling or non-ruling. This morning, as we commenced proceedings, Sikakane for the respondent asked for an adjournment so that he could come and see us in chambers about a particular issue. We duly adjourned, and he came to see us in chambers, and it turned out that the issue that he wanted to raise was exactly the issue that he has just raised now as a result of my giving him the floor, which, as we all know now, is that his client's position, that is the respondent's position, has changed from opposing the matter being heard in public with the media allowed to the opposite direction, to say that let the matter be open to the public in all respects. And after he had told this to the tribunal in chambers, as the president of the tribunal, and indeed as required by law, I duly consulted, or to put it properly, more accurately, I duly reconsulted with the Chief Justice telephonically about this particular issue. We did have quite some substantive discussion about this particular issue. But at the end of the day, we have come to a conclusion, which I'm now conveying as the president of the tribunal after that consultation, which is that the matter will be heard in public. The entire matter will be heard in public. The ruling, as my colleague has indicated, was emphatic about protecting the image of the judiciary. But we do not want to pretend, by we I mean me and the Chief Justice, we don't want to pretend to know the parties' case better than the parties themselves. If both parties, including the one we had objected against, then the matter being heard publicly, is of the view that it will not harm the public if the entire matter is heard in public, precisely because we don't know every aspect of their case at this stage. We feel persuaded towards inclining to allow the matter to be heard in public. I think that explanation was given, and should the need arise, more reasons may be given. But suffice it to say that after that reconsultation, and bearing in mind the position now lately adopted by the respondent, who must be fully conversant of every single merit of their case, of his case, we are inclined to do so. Accordingly, the following ruling is made. The hearing of this matter will be held publicly. Thank you.
Thank you, Chair.